Hi, my name is Ashley, and today I will be reviewing the case of the Federal Commissioner of Taxation versus Maloof. Maloof was a partner in a company which owned a partnership share of a company named Cresthaven. On the 25th of June 1999, Cresthaven entered a contract to purchase a retirement village development for $39.75 million. The contract was established on the condition that the vendor was responsible for obtaining the relevant planning permits and complete stage 1 of the development before settlement and transfer of the property to Cresthaven. At this time, Cresthaven paid a deposit of $6.5 million with the balance of $33.25 million outstanding. The development was meant to be set up as a managed investment scheme along with some other investors. However, the scheme was never registered and eventually the company was ordered to be wound up. No work had been completed at that time. Subsequently, the contract was terminated and the deposit of $6.5 million was refunded with interest. For income year ending the 30th of June 1999, Cresthaven reported a loss of $40,830,260, which included the full contracted amount of $39.75 million. Maloof stated that his share of the loss was $474,457. The primary issue in this case relates to the timing of when the taxpayer incurred the expense for the development. Does the taxpayer have the capacity to claim the full cost of the development in the 99 income year, or is it partially referable to another income year? The primary judge, Alsop J, performed an analysis of the case through the lens of Section 51(1) of the 1936 Act and Section 8-1 of the 97 Act. He also established an interpretation to the meaning of incurred and referable for the case. Based on his findings, His Honour agreed that the taxpayer's obligation to pay the balance owed in the contract was enough to constitute a deduction for the 99 income year. The judge cited similarities of cases Woolcomers and Raymore to support his findings. The Commissioner disagreed and appealed to the full Federal Court on the view that the contract was still in execution and relied on conditions to be carried out by the vendor before settlement. The Commissioner argued that only the deposit of $6.5 million is referable to the 99 income year, with the balance referable to a future income year should the conditions of the contract be complete. Judges Sundberg, Jessup and Middleton considered the analysis of the primary judge, and while they universally agreed with the interpretation of incurred and referable, they did not agree with the reliance on the cases of Woolcomers and Raymore and stated that although similar, they were materially different in nature. In both cases, the taxpayers were awarded deductibility in the referable income year for contracts they were obligated with reference to the purchase of goods. To illustrate, in the case of Woolcomers, the taxpayer used forward contracts, where an agreement for the supply of wool was established at a fixed quantity and price over the duration of the contract. The full Federal Court decided to allow the deduction in this case, and it was held that the contracted amount was incurred in the 1988 income year, even though the contract had not yet been fulfilled. This refers to the concept of an accrued liability being imposed on a taxpayer by an unconditional contractual obligation. At first glance, these cases appear similar to the present case. However, they are dissimilar in the sense that the contract observed in Maloof is conditional, meaning that the payment for the contract is not yet an obligation until the vendor completes stage 1 of the development. Based on these distinctions, their Honours agreed with the Commissioner and the taxpayer was denied the loss of $39.75 million for the 99 income year. In their findings, they state, every contract must be construed according to the intention of the parties, and upon taking a legal or jurisprudential approach, the contractual arrangements and surrounding circumstances must be considered in determining when the loss or outgoing has been incurred. The Court concluded that the balance owing on settlement was therefore not referable to the 99 income year. The legal principles considered in this case surround the application of the deduction and whether the contract itself is enough to have a committed and present liability. Taxation Ruling 97.7 states, as a broad guide, you incur an outgoing at the time that you owe a present money debt that you cannot escape. Further, it says, for the purposes of Section 8-1, it is sometimes not enough that a loss or outgoing has been incurred. The outgoing must also be properly referable to the year of income in which the deduction is sought. According to Taxation Ruling 94.26, the meaning of incurred with reference to a presently existing liability and Section 8-1 of the Act says that for a liability to be incurred, it must be due in the current year. However, the ruling also indicates that the disbursement is not necessary to be made in the year that it has been incurred. Anecdotally, the relevance of these principles are still in force today. Taxation Rulings 97.7 and 94.26 refer to the concept of timing for allowable deductions and the definition of incurred in context of this case to demonstrate the application on assessment for taxpayers. Tax practitioners should always be referring to legal frameworks when making decisions. Having a holistic view of client transactions, their intentions, their obligations, and their supporting evidence delivers a pathway to providing the best care of their tax affairs. Practitioners should have an awareness of cases such as this, as it demonstrates the difference in scenarios that can arise from the purchase of assets. Just because two acquisitions might look the same, it doesn't mean that they are, and they should not be given the same treatment. It is also important for a practitioner to understand the provisions in the Acts relating to general deductions and how they are applied to each set of circumstances. As a tax practitioner, when faced with a similar situation, an analysis of the conditions in the deed or the contract should be considered to ensure that the correct values are being applied in a manner appropriate for the situation.